I'd like to shift gears now and talk about another area that is of interest to me, and I think of interest to many of the attorneys that watch our podcasts, and that is one of suitability. The judge is the last line of defense for a transaction. Basically, the judge is determining whether the transaction is in the person's best interest. But who determines suitability? There have been some practices that I've written about, that I've observed, where people are telling people to, or advising people, or insinuating that they should sell their structured settlement payments and put it into alternative investments. And one of the things that concerns me is that the possibility that there's some type of tie-ins between the settlement purchaser and, let's say, a wirehouse or a stockbroker, or how do you protect a claimant from an unsuitable transaction if it's just being done on the papers, let's say, for example?
Right. I mean, suitability is a very big issue. There is currently no standard set up right now for suitability other than what the best interest standard that's written into the statute. And again, I firmly believe that if you comply with the best interest standard, then suitability is assumed within that. That's not been the practice in a number of cases, and that's where there's a challenge. I think, suitability from the standpoint of why is the seller selling in the first place is something that really gets back to what created the need for liquidity in the first place. If this is really a needs-based service where somebody's developed a need or a desire for liquidity, they're free from undue influence, they're of sound mind and body, they're capable of making decisions, they go through a process. They should be, they should be able to have an efficient path to getting liquidity where it doesn't create a dangerous situation for that individual. The court process is there, and if people comply with the statute, then suitability is taken care of. Other than that, what you would have to do is you would have to pass rules specifically designed to determine suitability, and that would involve a change in the law.
Okay, that's fair enough. Now I'd like to close by just talking about, because this does not seem to be covered in any Structured Settlement Protection Act, and that is how potential sellers are found and how they're solicited once they are found. And I've personally observed, and no doubt you and others have observed, ways that people are solicited that perhaps are in need of control. What are your thoughts on that?
I think with any niche financial product, the disclosures are really key, and I think that the industry is sorely in need of uniform standards and rules of the game to dictate what is and what is not appropriate. I've personally spoken with a number of sellers who didn't want to be accosted, and they got accosted by multiple companies. There's a widespread practice where people will go into court, get court records, use those records to contact individuals directly, and offer them sums of money that are way more than the individual wants or needs. And that practice currently is not regulated, and in my view, it should.
Now, in terms of regulation, I mean, as a licensed insurance agent, it's kind of interesting because Florida just came out with a bulletin where they were reminding people that it was not okay to pay a $25 wire fee for a claimant. For an insurance case where they're going to wire a certain amount of money, and the state said no, that's not kosher. So what do you think some type of limitations? What type of rules do you think should be out there?
Well, there's a number. A lot of companies advertise, and they wait for people to call them, and then they follow up and contact them. I have never personally had any problem with that practice, although it can be very expensive. I think what it really comes down to is what individual companies do, or what individual agents or brokers who work with companies do to solicit consumers. And this is an issue, that gets to the consumer protection laws. And I think we would have to see a change in the law to prohibit certain practices in order for there to be an enforcement mechanism to put an end to the practices that are dangerous. It's inevitable that there's going to be bad transactions, and bad transactions lead to bad law. The better way to approach this would be to be proactive and create a system that would prohibit certain bad practices. And by prohibiting those practices and having penalties, you would get rid of the bad actors. And then the needs-based business, the business that was designed to provide that release valve and that liquidity for people who needed it because their structure was no longer meeting their needs, that business would continue to go on and, in fact, would flourish for the well-run company. But it would put the bad actors out of business.
On a personal level, I personally believe that if there was some type of standards put in place that put it on a par with other financial services, I think that some of the negative feeling about the secondary market that's out there could probably dissipate. How do you feel about that?
Oh, I absolutely think that it's very hard for a reputable secondary market company to compete in today's environment because of bad practices by certain companies. And I think that those companies are, who want to do the right thing, who use institutional capital, who try to comply with the spirit and the letter of the state transfer statutes, are at a disadvantage. The business has become more expensive for them, and it's the internal policing, because they do the right thing, has become more expensive. And so they would very much support appropriate, reasonable regulation. I will say, however, that limiting discount rates, as some have attempted to do, in my estimation, is not the way to go about it.
Okay. All right. And what is the problem with limiting interest rates? Can you give us your insight in that?
Sure. I mean, a lot of the sellers don't have access to any sort of conventional funding. They can't go to the bank and borrow at all. So, the rate is not always relevant when somebody has a need. If somebody has a financial need, and you say, well, you can only do it at this rate, you're really saying you can't do it at all. Because if somebody is receiving a certain monthly payment over a long period of time and they need a chunk of cash, it doesn't really matter what the rate is if they can't access capital. So, again, you're going to make it impossible to do smaller transactions, and you're also going to create a situation where for folks who don't have good credit, they're going to be completely denied access to capital altogether, and that creates more problems than it solves, in my estimation.
Okay, and do you think a licensing standard or some of the standards that are that apply to insurance agents, securities brokers, banking, do you think some of those should apply to the structured settlement secondary market?
Absolutely. I think some sort of licensing system would be ideal, because that way you would have, and I think you need to have both licensing and penalties. And I think the licensing would create opportunities for some, and I think it would also create a deterrent to really bad practices. You have to have consequences for violating this. I believe that a lot of these bad practices actually violate either the spirit of the letter of the state transfer statute. But there are no clear-cut penalties right now, the way the laws are written. The excise tax, it really doesn't work, except in limited circumstances as a headache for certain companies.
Right. The excise tax is primarily there to be a tax on the factoring discount. So if you don't comply with the act, you get a tax on the factoring discount, but it doesn't appear to deal with any type of behaviors that are performed or by bad actors in the industry. One more thing, we only got a few more minutes left on the show. There are a number of companies out there that appear to be using fictitious names, and do you see any danger in that? I'm not talking about fictitious names for a business or a doing business as, but I'm talking about creating phony individual characters and holding out their business as if these fictional characters actually exist.
Yeah, I mean, I don't have personal experience with that, John. I know that there's a structured settlement watchdog who apparently looks out for that kind of thing. It's not been my focus, but I think false advertising always creates problems, and there are some risks to doing it. I mean, there are state attorney general who will enforce false advertising statutes in certain states, so there's risk to that type of thing, and any sort of fraud exposes companies to very significant charges, both criminally and civilly. that could result in very significant damages.
Okay, great. Well, Eddie, I really appreciate your time and your insight. I think our viewers and listeners will be really interested in some of the things that you've had to say, and these are very important topics. And hopefully, to those of you who are viewing and listening to this podcast, I hope that you'll take some of the things take some good things from this, and hopefully it's an inspiration to make some changes, some positive changes for the industry. Thank you again. Have a great day.